Hello, everyone. This is Ryan Thurman with Contact Center Compliance, here today with our compliance webinar with Christine Riley from Loeb & Loeb. We've got a full deck of information all about everything you want to know about TCPA for debt collections. We're going to cover a little bit about some of the telemarketing rules. And we're really going to focus on kind of a practical guide to TCPA. Christine has extensive experience working with companies that are in litigation and advising them on TCPA strategies, and she's got some real-life examples of how to help people obtain the proper consent. So we're very excited to have her today present this material and give us some strategies to work with going into 2014. Welcome, Christine.
Thanks so much, Ryan. Appreciate the introduction.
So before we get into the full agenda, just a couple housekeeping items. As you've got questions, as I'm sure a lot of you do as we go through the content, you can use the GoToWebinar tool to just text those over, and we'll try to pick those up as we go, or at the end we may have some questions that we can allow for as time allows. We're going to try to wind this up in about an hour, and we are also having this recorded so that if you've got other colleagues you want to share it with, we'll get a link out afterwards along with a link to the slides, so you'll be able to have follow-ups. You don't have to take complete notes because there's quite a bit of information here. Just wanted to give people a quick synopsis of what we do. A lot of people know us in the collections and call center space for some of our compliance services. We've been around about 11 years, got a good track record doing do not call scrubbing, as well as we do a lot of work with clients that need TCPA scrubbing. So we can do wireless identification. Anybody that's on the phone that needs an analysis of what type of data they're getting, whether it's cell phones or landlines, or wants to look at a solution, we do offer a free test, and that will be available for anybody that's on the call. We also are a publisher of the really only compliance guide that's out there that focuses on call center rules. So if you've got legal folks that need a way to look up the rules, keep track of state registration, licensing, we do a guide as well as for training so that you can prove that you train your reps and managers. And we also do some data enhancement, keep people updated as far as making sure the cell phone numbers you do get consent for example, that it's the same person that gave you the phone number. That's another overlap with TCPA that you see a lot of. Other things that are real important with TCPA is automating the process. You've got a real quick scrub period under TCPA, only 15 days, so you want to make sure that you can automate that either through some sort of FTP like we offer, or API. Very kind of easy to get off track, especially with ported numbers that used to be landline that are now cell phone. That file does change daily. We can basically customize plans based on companies' volume and how much scrubbing they're going to do, how many agents. Just like anything in telco, it's available kind of on a tiered pricing schedule. We also provide the actual raw files to a lot of our clients that want to do their own scrubbing for TCPA, whether that be the carrier data. Most of the time it's the carrier data plus the ported list, an automated feed. They bring it in, they do the scrubbing. So that's another option to look at to supplement an internal system. I'm not going to get too complicated into all the different options, but there is lots of different ways to scrub with us, lots of ways to incorporate your opt-ins, and that kind of leads me into Christine's presentation, because that's really what we're going to be talking about is how do you get the opt-in, how do you obtain consent, and how do you make sure the consent you're getting is the one that's going to stand up against a lot of these professional litigators and the kind of extraordinary amount of TCPA litigation that we're starting to see. So I'm going to turn this over to Christine and let her give you guys what y'all came for.
Thanks, Ryan. Well, good morning to those on the West Coast, and good afternoon to the rest of you. I am particularly excited to do this presentation as I did a very similar presentation in October for the Financial Services Collections and Operational Risk Conference that was in Chicago. And the reason why I'm doing this webinar is because there was a request to have a webinar on it, and it was a very popular session that we had. and we get a lot of positive feedback on the practical implications. So I want to thank Contact Center Compliance for agreeing to host this webinar, and excited to give this presentation. Let's talk a little bit about what this presentation will not cover first. We're not going to be talking today too much about the Fair Debt Collection Practices Act, the FDCPA, and we won't spend a ton of time talking about all of the intricacies of the TCPA. I'm assuming that most of you on this call already know what the TCPA is. You've probably already listened to a bunch of webinars and presentations about it, and you've probably at least listened to David Kaminsky, my colleague, that's talked a lot about the TCPA. We won't spend a ton of time talking about all the legal intricacies. What I really want to do today is I want to give you the practical how-to. One of the things that us lawyers do, and we tend to do a lot of, is we talk about what the TCPA says, what the cases say, and what the confusion is. But what we don't often do a really good job on is how do you deal with the TCPA in everyday business behavior? What's the practical implications affecting your business? So I want to focus on that today, because I think that's a really important aspect of the TCPA, aside from the case law. How does it affect you? How do you deal with it? How do you stay compliant? So those are the goals for today. I'm going to briefly talk about today's topics on slide 2. We will talk a little bit about the basic provisions that govern debt collection calls. I won't spend a ton of time on this, but I want to provide the groundwork for what we'll discuss later. I'm also going to give you a very short list of some really basic consent rules that are applicable to debt collection calls. Then I want to talk about what are the best practices for putting together a policy and procedure for getting the consents that you need to contact consumers. And then I want to move into the how-to. How do we get the consent that we need in order to remain compliant with the TCPA? And we're really going to get into it today. We're going to look at specific methods to do this, and we're going to look at specific examples. You should not be leaving this call today not having some practical tips to arm you with dealing with this particularly crazy statute. And then I want to move into record keeping, because in my view, you really can't talk about consent and how to obtain it without talking about your record keeping. You can get all the consent you need, but if you don't have records to prove it, you pretty much can assume you don't have any consent. And I know we have here on this list the new FCC rules for telemarketing. And I know some of you are saying, well, what does it have to do with us? We're not telemarketers. Well, I'm going to say this. We will talk about that very briefly, because it is possible that the new rules can affect your business, even if you do debt collection. And we'll talk about the specific circumstances under which that might be the case. So with that, let's turn to slide 4. What are the basic provisions that govern the calls that you make to consumers? Well, as you probably know, there are different provisions for residential calls versus mobile calls. Let's talk about residential first. The basic rule here is that you don't need consent to call residential phones because they're generally considered exempt. And we've got sort of our Dan, the debt collector, here with the thumbs up, because great news. This is one area where we could say, for the most part, we don't have a lot of concern. So if you're making using pre-recorded messages or using artificial voices to call residential phones, you're okay. So the residential phones, for the most part, don't really give us a lot of heartache. Let's go on to slide 5. Let's talk for a moment about why is that? Why do the residential call provisions not really impact debt collection? Well, you have a provision here in the statute and in the regulations that talk about the different exemptions there are for certain calls. and I've listed them all here for you. One thing I want to make a note of, and this becomes sometimes confusing, when we're talking about residential phones, we're only concerned about artificial voices or pre-recorded messages. That is the only time you need to worry about the TCPA when you're calling residential lines. So that means you can use an auto dialer to call residential lines without implicating the TCPA. I know sometimes that's lost, but it's a really important point. You can auto dial a residential phone as much as you like, and you do not have a TCPA problem. Now, looking at this list, there are a whole bunch of different exemptions for calling residential lines. And I want to draw your attention to two of them, because these are the most applicable to the debt collection industry. There is the fourth one, or actually the fifth one down, says you can initiate a telephone call using an artificial or pre-recorded voice to deliver a message to a residential phone unless the call is made for a commercial purpose but does not contain an advertisement or constitute telemarketing. And another important exemption that used to exist but no longer exists is, as you could probably see, the very bold red crossed out language, the established business relationship exemption. That no longer exists for residential calls as of October 16th, 2013. So you cannot rely on that for making residential calls. Turning to slide 6. We're still here on residential calls. What has the FCC said about it? Well, the FCC has said that the debt collection calls have two exemptions that are applicable. One is the one we just talked about, that it's a commercial call, but it doesn't involve some kind of advertisement or telemarketing. And the other exemption that the FCC specifically mentioned was established business relationships. Well, now that the established business relationship exemption no longer exists, it looks like the debt collection industry is now left with one exemption, and that is the commercial calls that do not involve advertisements or telemarketing. At some point, there was discussion about making a specific exemption for the debt collection industry and for the debt collection calls. Well, the FCC spoke about this in its 2012 order and said that debt collection calls are not telemarketing, and as a result, they didn't believe that there needed to be a specific exemption for debt collection calls. So there's no specific exemption for debt collection calls, but when you're calling residential lines, you do have the exemption under the commercial call, but doesn't involve an advertisement or telemarketing. Let's turn to slide 7. Well, here is where we run into problems. And for most of you, this is really the heart of the issue. It's your mobile calls. You want to call consumers on their mobile phones because that's the way to reach these consumers. We all know we carry mobile phones on us every day. The statistics on mobile calls are really staggering. The percentage of use, and I think they said within minutes of getting text messages, those are read. So mobile phone is a very effective means of communicating with someone. So as a result, businesses want to reach consumers on their mobile phones. They know it's effective. They know they can reach the consumers. The problem is that there are much more strict rules on contacting a consumer on their mobile phone. So this is really where the heartache comes from. And this is why Dan, our debt collector, has a very unhappy face here, because when you're calling a mobile phone, you need verbal or written consent, regardless of why you are calling that consumer. And that would include debt collection calls. So you don't need any kind of consent if you're calling residential phones because you have an exemption. But when you're calling mobile phones, you absolutely need some type of consent before you make that call. So that really is the sticky point, and we're going to address how do we get that consent for those mobile phones? Really briefly on slide 8, these are the provisions that address mobile phones in particular. And the one here on slide 8 is the one that's particularly applicable to the mobile phone and debt collection calls. This is the provision that's existed for quite a long time now. It basically says you need to have prior express consent. One of the things I want to point out about mobile, and this is different from residential, is that you not only have to be worried about artificial or pre-recorded voices, but it also involves your automatic telephone dialing system, otherwise known as ATDS. So unlike the residential, you have to worry about pre-recorded messages, artificial voices, and if you're using an auto dialer to call your mobile phone. And of course, there is no type of non-commercial purpose or other type of exemption for mobile, which is why it is so difficult to call mobile phones without stepping on the TCPA.
That applies business to business as well, Christine, right? There's no exemption for B2B or existing customers.
Unfortunately, no. And it's funny you mentioned that, Ryan, because I have a case right now where we are looked really far and wide to try to make a B2B argument. And we thought maybe we came up with something crafty, and we went to mediation, and the mediator told us, I don't think so. So I think it's pretty safe to say that unfortunately your B2B calls on mobile are still covered. You still need some type of consent. And unless the law changes, that's what it is for now. So anyway, this provision that's on slide 8 really governs informational calls and non-telemarketing calls. So it just says prior express consent. Really briefly on slide 9, we're not going to talk a lot about this today because it doesn't really impact debt collection, but this is a new provision that is for telemarketing to mobile phones. You'll notice that this new provision talks about including or introducing an advertisement or telemarketing. And now, of course, the FCC has said if you're going to telemarket, you're going to need prior express written consent. Verbal consent is no longer sufficient to call those phones. Doesn't really impact us, but I wanted you to be aware that there's a new provision. It deals with telemarketing, and it has even more strict requirements than what we've already talked about. So let's talk a little bit about what some basic consent rules are. I'm sure you probably know most of these rules and you've heard about them, but let's set a groundwork for why this is all important. Why is this significant? Why do we care? Well, this is why we care. Let's talk first about what consent means in debt collection. So we have on slide 11 a question. Does providing a mobile phone number evidence express consent to be called in relation to a debt? And I've got good news. The FCC has said yes, it does. So what does that mean? It means that if a consumer is providing their mobile phone to a creditor, for example, as part of some kind of written application or other type of written document, it reasonably evidences prior express consent by that cell phone subscriber to be contacted at that number regarding the debt. And what the FCC has basically said is if you're going to voluntarily and knowingly give your phone number, what you've done is you've essentially invited contact or permitted the contact, all of which is really good news. Now, of course, with all good news, there's always a footnote, and it's always the case when it comes to the TCPA. So turning to slide 12, what you should know is that there are some courts out there that disagree even with the FCC. You've probably heard about these cases. You've probably heard about this judge by now. But there is a judge. His name is Judge Scola. He's in the Southern District of Florida, and he is quite notorious in the TCPA area now. So there's at least 2 cases where he's come out and said, listen, I know what the FCC has said, and I don't care what the FCC has said. I don't think that if you give your phone number as part of an application, that that's necessarily prior express consent. He said it may be implied consent, but I don't think it's express. And he's refused to give the FCC deference on this particular issue. He's been very consistent in these rulings, and this is at least 2 of these rulings. So let me say this. Judge Scola is the exception. I'm not really aware of any other judges that take this kind of stance. So generally speaking, you should be fine if you are getting a consent from the consumer or the debtor as part of an application, if they're providing their cell phone number as part of an application or process. That should be sufficient. But just realize that depending on what jurisdiction you may be in, there could be judges that say that's not the case. It's completely wrong. It's very frustrating. But that is what the law is. And until Judge Scola gets either reversed or reprimanded or something else for this, that's what we're stuck with. But generally speaking, you should be fine. Turning to slide 13. I want to take a question. I see a really good question here. And this is a question that comes up a lot. Is there an exemption for manual direct dialing? I've got good news. If you are making manual calls, you do not implicate the TCPA. So let's say you're actually making a manual call to a mobile phone. That's usually person to person. I'm texting, let's say, Ryan, or I'm calling Ryan on his cell phone. The problem is that as businesses, it's very unlikely that you are doing anything manual when it comes to mobile phones. You're probably using some type of auto dialer in order to send these messages out en masse. For your residential phones, you are probably, if you're calling them on a manual system, and you're not using pre-recorded voices or artificial voices, you should be fine because it doesn't implicate the TCPA. Now, one thing I want to note is there is a lot of confusion on what it means to make a manual call. That's kind of a separate topic for another time. But the key is, does your system have the capacity to auto dial? So even if you may be making calls in what is considered a manual way by pressing buttons or doing a click to call or preview dialing, that may not be sufficient to take you out of the auto dialer definition. So generally speaking, manual calls are not implicated by the TCPA, but be very careful on what you're considering manual. And I know, having spoken to many clients about this, their definition of what a manual call is not the same as mine or what the law says. So be very, very careful. All right, let's talk about some consent rules. I'm going to go through these pretty quickly, but I want to set the groundwork for how we get to consent. So this is the section of why do we care? Well, here's one thing you should know. Rule 1. If you're getting express consent, it's only deemed to be good if the mobile number is provided by the debtor to the creditor. So here is an implication for debt collection. Skip tracing. If you're doing skip tracing, that is not ordinarily considered to be express consent to call the consumer. There's a decision from the Ninth Circuit that talks specifically about this. It's the Meyer decision listed on the slide. Skip tracing is not express consent. If the consumer gave their number to a third party and that third party gave it to you, probably not prior express consent. And we'll talk a little bit later about debt collectors and the relationship with creditors and how that all works out. But generally speaking, that debtor needs to give the person calling, or the creditor on behalf of who you're calling, their phone number, and not through some third party. On slide 14, a few more rules. what you need to know is that consent is specific to the creditor. What does it mean? It means that if you're having your affiliated companies or entities call that number, but the consumer gave their number to a particular creditor, that's not express consent. It doesn't entitle the creditor to call on behalf of other creditors, even if they may be affiliated with that creditor. So you got to be very careful. Another thing to keep in mind is that consent is debt specific. That means that if you're getting the phone number with regard to a specific debt, but that consumer has another debt with you, it doesn't necessarily mean you can call them on their cell phone about a separate debt. That is the rule even if you have the same creditor. So let's say a consumer gives their mobile number on their auto loan. But that company also has, let's say, a loan for a motorcycle. If they've only given you the phone number on the auto, that's your express consent. You cannot call on the separate debt unless you've gotten the consent from the consumer. Also keep in mind that if you're capturing phone numbers by a caller ID or some other device, that is not consent by the debtor. It has to be more expressed than that. On slide 15, this has become, in the past, somewhat controversial. The FCC has said that prior express consent is granted only if the mobile number was provided during the transaction that resulted in the debt owed. What does that mean? Well, it basically means that if you get consent any time before the call is placed, you should be good. There was a little hiccup here in the Ninth Circuit. The Ninth Circuit, not surprisingly, took a very harsh reading of the FTC's opinion and basically said that consumers who provide their cell phone numbers to the creditors after the time of the original transaction are not deemed to have consented. When this decision came out, we said, what? So wait a second. If we didn't get the number during the original transaction, but we later got it, we can't call them? The decision made no sense. And the Ninth Circuit itself had to recognize that the decision was wrong and that they had to fix it. So of course, after coming under a lot of heat and a lot of objection, the Ninth Circuit actually came back and amended their order and basically said you can call that phone number in connection with a particular debt if it's given before the call in question is placed. And you'll notice quite a change in the language from the May 2012 opinion and the October 2012 opinion. So what the rule is this. You need to have the consent prior to making the call. It's ideal that you get it during the original transaction, but that's not always possible. The bottom line is you need it before you make the call. And lastly, on slide 16, here's why we care. Well, creditors are responsible for demonstrating that the consumer provided the prior express consent. This all goes back to record keeping. Point number 5 on this slide is saying the burden is on the creditor to show that they obtained the consent. So let's say a consumer says, I didn't tell you you could call me on my cell phone. I never said that. The burden is shifted to you to prove that you have the consent to call that consumer. That is why record keeping is so very important. And lastly, on point 4, the creditor on whose behalf the auto-dialed or pre-recorded message call is placed bears the responsibility for any violation. So if calls are being placed by a third-party collector, they're generally treated as if the creditor itself placed the call. Now, it doesn't mean that third-party debt collectors are out of hot water. Unfortunately, third-party collectors may also be liable for a violation. So you have creditors on the line here as well as third-party debt collectors. That is why both need to be very concerned about the TCPA and make sure that they have the consent prior to making the call. Let's move on to talk about best practices. And I want to be clear about what this slide is. Best practices is what is recommended in order to have very robust and effective consent. Not everything on this slide is a legal requirement, and I want to make sure we understand the distinction. Best practice means optimal. What we'd ideally want to see if we had to defend a class action, but not necessarily what the law requires debt collectors to do. So let me give you sort of what the best practices you can implement are, and then we can talk about how we might be able to still have good consent, but maybe we can't fulfill all of these, and that's okay. So I'm going to tell you this. Obtain the consent in writing. Now I'm sure you're saying, wait a second, I thought I only needed prior express consent. It doesn't need to be in writing. In writing is only for telemarketing. And I'm going to say you're correct. The statute says it must be written for telemarketing and doesn't require writing for debt collection calls. But I want you to think about this scenario. The consumer tells you by telephone that, yes, I give you consent to call me on my mobile phone. Let's say you don't record that message, that telephone call. You call that consumer on their phone, and that consumer says, stop calling me, files a TCPA class action for all calls made nationwide, and says, I never told you that, or I didn't give you permission, or you spoke to somebody else. Now what? That's the problem. I recommend getting consent in writing or some record of it every time, because the burden is on you to prove the consent. And if you cannot prove the consent, you might as well consider yourself not to have any consent at all. And this happens, and it happens a lot. Consumers either forget that they gave you consent, or they lie and say, I never did it. I never gave you the consent. I spoke to a fairly large auto finance company just recently who has gone through a ton of arbitrations on this issue, where consumers are saying, hey, I never gave you consent. Prove it. The burden comes on you. So, best practice, get the consent in writing. If it's going to be a telephone call, make sure the call is recorded. Another thing to keep in mind is it's ideal, if at all possible, to get your consent at the outset of the relationship with this consumer. You can get it during, you can get it later, but the easiest time to get it, and probably the less likely a consumer is to refuse the information, is when the initial relationship starts. So that means third-party debt collectors talk to your creditors, make sure they're doing these things, they're getting the phone numbers so that you can make the calls. But bottom line, you need the consent before you make the call. Talk a bit about your disclosures. My recommendation is to be as specific as you can in making the disclosures to the consumer. Now, I realize that this isn't always practical for your business, and I realize that you may not be comfortable revealing all of this information, and that's okay. But here is what's suggested. Name the specific creditor. Make sure they know who you will be calling. You might consider naming your third-party collection agents or agencies, if you can. Not necessary, but you might consider doing that. You might also consider disclosing to consumers that they will be contacted either through pre-recorded voice messages or by an auto dialer. And the reason I mention this is there is a 2008 FCC order that talks about this issue specifically. And so I'm going to read it to you. The FCC has said, we encourage creditors to include language on credit applications and other documents informing the consumer that by providing a telephone number, the consumer consents to receiving auto dials and pre-recorded message calls from the creditor or its third-party debt collector at that number. So do you need to say you're going to use an auto dialer or a pre-recorded message? No, don't need to say it. It's encouraged, specifically with respect to anything that's in writing. But if you can put it in, and it's not going to affect your conversion rates on who gives consent, I would recommend putting it in. You also need to make clear the phone number that will be called, the specific phone number. And you also might make specific mention to the fact that debt collection calls will be made. Now, I don't think you necessarily need to say debt collection because no consumer really likes to hear debt collection. But I think there are some crafty ways of getting that point made without having to say debt collection. And we're going to talk about that through some examples. Next up on our best practices on slide 19, the FCC and the Federal Trade Commission love this expression, be clear and conspicuous. What that means basically is making sure that the consumer sees it. You know, these kinds of disclosures. You got to make sure that it's not hidden, that it's not printed in some very small font that no one can read at the bottom of a web page. It also means it shouldn't be buried in some type of unrelated information where consumers not likely to see it. The idea is make it so that the consumer can see it. The consumer can see it and says yes, you've got a more robust consent. If you can, present it in a separate document. And I realize this is not always practical for a lot of you. Sometimes it's part of a larger process, part of your document. That's okay. If you can do it separately, great. If you can't, well, at least tie in the documents with your consent. And there are ways that we can do this. Lastly, let's make sure that we're getting the magic language that we need. For voice recordings, you want yes, you want I agree, you want I consent. You want to hear quite clearly that the consumer is giving their consent to be called. On web forms, online, I recommend doing manual checkboxes. An I agree button, for example. You don't necessarily need both the manual checkbox and an I agree button, but the more, the better. The reason why, there's more to argue about why there was express consent. And you can also use handwritten signatures that are on written forms. Those work as well. So those are the ways in which, well, those are the best practices in order to get the consent that you need. Now let's talk about how to. How do we actually do this? How do we get the consent? Putting together all of these rules that we've been talking about and these best practices, what does it look like to the consumer? Turning to page 21. Here are various methods you can use to get the consent from the consumer. There's, of course, your very traditional paper consent where you have purchase agreements, you have sales slips, loan applications, credit applications, anything in writing where you can give the disclosure and say that you're looking for the consent and have them sign off on something. That is sort of the more traditional form. Website is a great way as well to get consent. And given the way that we use the internet today, it could be a very effective means of getting the consent that you need from these consumers. So if you're doing online purchases or sales, you can make it part of that sales process online. It is not hard to put together some language with a checkbox or an I agree button and have the consumer consent as part of the larger sales process. It tends to be very, very effective. Another way of doing it is a login or sign-up process. And I could tell you that just the other day, I had to find out what my balance of my student loan is. And God knows how many years I'll be paying this debt for. But I decided, let me find out what the balance is. And I had not logged in for a long time. And I was really pleased to see this particular company did something very well done. I went to log into my account, and hadn't done so in a very long time, and it told me, our records indicate that your primary or secondary phone is a cell phone. Please review the cell phone terms and conditions below and select agree or don't agree. Click submit to continue. It had a very clear laid out process, and it said terms and conditions. By providing my telephone number, I authorize the company, its agents, affiliates, and successors, including subsequent servicers, to contact me at this number using an autodialer, text, or pre-recorded message, even if it's a cell phone, and I may be charged by my carrier regarding any of my current or future loans. It had my number in the box, and I had to click either agree or don't agree. And then I had to click submit. I don't have this in the slide today, but if you're curious to see the layout, please email me and I will send it to you. I think this is a very effective form. I, of course, said I agree. I clicked submit, and now that debt collector can call me if I should decide never to pay my student loan, which won't happen, by the way. So that's a way of doing it. Logging in, consumers looking at their accounts online. When they log in again, have some kind of process like this in place where you can get the consent. You can also do it online by managing preferences or some other type of online transaction. Make it part of the process. Moving on to slide 22, you can also do it by telephone. You can make it part of the sales process when you initially have the loan or application that's being submitted. And you can do it also through customer service calls. Let's say you have a consumer that calls in. They have a question about the balance of their loan. Great opportunity to get the consent that you need if you do not already have it. Another way is text messages. And I know we're a little bit skeptical about the text message way, but I do think there is a way to do this, and we're going to talk about that very shortly. Email is also a great way. You can have consumers give the disclosures in an email and have the consumer respond. I agree, I consent. Or what's even more effective is if you send an email and you include a link that goes to a separate web page with your disclosures and the consent that's needed. That's a great way. You know, between the two, I like the idea of going to a specific web page that can capture the consent that you need. You can also do this by mail, postcards, account statements. Basically, the bottom line here is any communication with the consumer can be a great opportunity to get the consent that you need. And these are all different methods that you can use. Text messages, emails, U.S. mail, written applications, voicemail, website, all good ways of getting consent. On slide 23, very briefly, this is what the e-Sign Act says about how you can get written consent. It's along the lines of what we've been talking about. One other way I want to mention specifically that we haven't already talked about is telephone key press. You can have an IVR system that when consumers call in, they can hear a message. You can put your disclosures. Have them press 1 if you consent. Press 2 if you do not. That's another way of getting the consent that you need. I also wanted to mention that there is a checkbox here to the right where something's partially checked. Do not pre-check your boxes. Do not partially check your boxes. If you're going to use boxes, have the consumer check the box. It is a very difficult time to argue that the consumers give a consent if you've pre-checked boxes. It's called a negative option. It's not recommended. I would not do it. And I would make it so that you code your programs online so that if a consumer doesn't check that box, they cannot proceed to the next page. You've got to program it. You've got to make it technologically impossible to proceed until you have the consent that you need. Moving on to 24. I'm going to talk about this really briefly because this came up during one of the last presentations that I did. And the question I got was this. Well, Christine, what about if we put it in our terms and conditions, we put this stuff in our privacy policy, or, we put it in the contract, and there's a little, there's something in there, a paragraph that talks about consumers giving us consent. Isn't that enough? Well, it's great to have stuff in your terms and conditions. It's great to have stuff in your privacy policy, and it's great to have stuff in your contract. But if these consumers are not seeing this and not agreeing to these terms, you're going to have a very difficult time showing that that consumer gave you the express consent that you need. Let me give you an example. Here's a contractual clause that you might consider putting in an agreement. And it says you're basically allowing the creditor, its agents, assigns to call you at any number, whether expressly provided or obtained through other means, including any future numbers. This provision is specifically thinking in mind about skip tracing. I think it is very questionable that this kind of provision is going to get you the express consent that you need. It's going to be an uphill battle. Does it mean that you shouldn't put it in your agreements? Not necessarily, but it just means I would not rely on this type of language to get the consent that you need. I think you'd have a hard time convincing a court that the consumer agreed to this language, you skip traced, you got their new number, and they consented. That would be a tough case to make. Same thing, well actually no, the next one is actually a little bit more palatable. This one says that the creditor, you agree to notify the creditor if you change your phone number, and you agree to provide new telephone numbers. I generally like this provision. It encourages consumers to give new numbers, but the problem is, what if they don't do that? Well, you've got maybe a breach of contract, but that doesn't necessarily get you very far, unless you plan on filing a lawsuit against your debtor. So I think it's good to have. The issue with that is the recourse can be kind of difficult if the consumer doesn't comply. But I certainly think it encourages consumers to provide information they need. We're going to go over some specific examples, and then I'm going to leave several minutes to discuss other questions that you may have. But the rest of this presentation basically goes into what is the language that you can use to get the consent that you need. So let's look at 25. This is an ideal consent disclosure. You have a manual checkbox. You're very clear that by providing the number and checking the box, you're giving the mobile phone number. I like the language that says, I verify this is my mobile phone number. The reason being is that even if you call a number that you think is the consumer, or they provide the wrong phone number, an inadequate, a phone number you call that's accidentally made, or the consumer gives you the wrong phone number, there can still be TCPA liability for that. So you want to encourage the consumer to verify they've given the right phone number and that it's theirs. You want some kind of representation saying, this is my phone number. Of course, you have the consent language, I consent. I think if you're going to use text messages, I would encourage you to specifically reference text messages so they understand they may get the messages on their phone. It's not required, but it's recommended that you do that. Here's the language that you can use to talk about debt collection. Relating to my account or my relationship with, and the name of the creditor. Relating to is a very broad expression in the legal field. It is considered and interpreted to be very broad, which is why I like it. So that's one way of saying that you may be calling about someone's account in debt collection without actually saying it. There's also the subsequent sentence that says, I understand these calls may relate to the handling, servicing, and billing for my account. That also encapsulates debt collection. Underneath is another type of consent, just another example. I consent to receive telephone calls relating to my account via automated technology. It's just a shorter way of saying it, but it's also an effective way of getting consent. Moving on to 26. What I want to point out on this one, I mean, this one is pretty clear, but I want to point out the first line. Should the name of the creditor, its agents, or assigns. Let's talk about the assignment issue. This is important. You want to make sure that your assigns, if this loan is given to another party, that they also have the consent that they need to call. So it's good to say the name of the creditor. It's good to say the name of the agent and to specify assigns so that we don't get into this argument of, I gave my phone number to so-and-so, but then the loan was transferred and I didn't give my consent to the person to whom it was transferred. You want to avoid that. So mentioning that in your consent can be very effective. This is a pretty clear consent. You check a box, you sign it. This is something that can be contemplated for something that's in writing. It could also be done online because you can also use electronic signatures. Let's talk about telephone. How do you do it by telephone? Well, this is an example that I've put together about how you can take advantage of customer service issues, where consumers actually calling you and they have a question about their account. Here's a great opportunity to get the information you need. Of course, agents are going to need to know what phone numbers are on file and make sure they have the phone numbers. But if you don't have that mobile number and you want to call it, have your agents give them a script to get the consent that you need. And here is some language where you can do that. You want to make sure that the consumer is being very clear and that they're giving the consent. I agree, have them say yes, no, and you may also want to follow up with these consumers by saying, do you understand that these calls or text messages may include service calls, account notifications, and calls regarding payment? Please say yes or no. What you need to keep in mind on telephone calls, you need to maintain records of the voice recordings. If you don't have the voice recording, you don't have evidence to prove that they gave you the consent on that call. And here's something else very important. If you are going to record telephone messages or telephone calls, you must tell the consumer that you're doing that before you record the message. And so maybe you don't want to, record the entire conversation. You at least have to let them know when you are going to record and give them notice. Especially here in California, it's a very important law, and I see a ton of class actions filed about not knowing that conversations are being recorded. So make sure you're telling consumers that you will be recording the call. A lot of companies do this by making it pretty much part of standard operating procedure. When you call in, there's a message that says, these calls may be recorded for quality assurance purposes. That's also another way of doing it. On 28, we've already talked about this, but what I want to point out on slide 28 is this is something that's contemplated for our online forms. I think this is a great opportunity when you're online to not only get the consent from the consumer, but have them also saying they're agreeing to your terms and conditions and the privacy policy, and have hyperlinks to both of those things. So you've gotten 3 things done in one. You've gotten the consent you need, you have them agreeing to your terms and conditions, you have them agreeing to your privacy policy. That's a lot of information, a lot of consent, all wrapped in one. Great way of getting it if you can do it. On 29, this goes back to the example that I gave earlier about my student loan. Logging into the system and getting a message, just like what happened to me the other day. It is a great way to get the consent if you don't have it. When the consumer logs in, you can say, we realize you don't have the phone number, we would like it, and this is some example language of doing that. Very clear, have them put in their phone number, check a box, and make it part of the process. And you want to present this to the consumer in a way that is positive. And, that might be, an art form of messing with the language. But here's one way of doing it. It's staying up to date on your account, being in touch. This is the kind of language you want to use to motivate people to want to give you the consent that you need. Let's also talk about text messaging. I know a lot of you have questions about this. I get questions about it all the time. On slide 30, here's one way of doing it. You have some type of signage, whether it be on your account statement, it's online, it's somewhere else where you're contacting or communicating with the consumer, and you're encouraging them to text you in order to get more information about something or to consent to having them call you on your mobile phone. This is how you do it if you want to use text messages. You have some kind of signage saying, would you like to receive information on your account, calls on your mobile phone, give the disclosures that you need, and then have them text mobile to your short code or some other phrase, or I consent to a specific short code. Next, what you do is preferably you have a double opt-in where you respond to that consumer via text message saying, you're signing up. You're going to get these messages. They're going to be sent by automated technology. Reply yes if you consent. If you get this, you have two, what we consider a double opt-in. The consumer said yes by sending you a user-initiated text message, and two, you have them confirming that this is what they want to do. And then you can send a confirmatory text message saying, yes, you're signed up. You'll be receiving your messages. I will tell you on a whole that text messages can be, there can be very risky. And there was a lot of lawsuits on text messages. So if you're going to do something like this, make sure you're doing it right, consult an attorney. But if you really want to do it, this is one way of getting it done. I know we're running out of time here today, so I'm going to go very briefly through a few things. Slide 31 just gives you an example of how to do it by email. Responding to an email or having consumers go to a very specific link that has the disclosures and the consent and has them agreeing to it. So we already talked a bit about this, but here's some language you can use to implement that. On 32, here's how we can do it by mail. If you're sending your consumers account statements, you're sending them notifications, another great opportunity to get what you need. Have them either sign something that's part of those forms, have it postmarked, postage prepaid so they can just send it on in, or have a website they can go to, have them text to a short code. There's so many different ways you can do this. If you're sending mail, that is an opportunity you can use to get the consent that you need. This is just one example of how to do that, and that's on slide 32. Very briefly on record keeping. Everything I just told you is for naught if you're not keeping records of your consent. It is so very important that you keep records. You should be keeping your records for at least 4 years. The statute of limitations is 4 years for TCPA cases. You want to make sure you're documenting the date and substance of any changes. You want to make sure you keep detailed records. One point that Ryan made in the beginning that is very important, you need to scrub your DNC. Very, very important, both the federal and any internal lists that you have. And slide 34 just talks about having some written suppression policies in place, ways of recording information so you have records, whether it be screenshots or templates. And another point I want to impress upon you is monitor your consumer complaints. I think consumer complaints are a gift. They're a gift because they signal to you that something may be wrong or there may be an issue. Listen to those complaints, monitor them, address them, and figure out where you might have loopholes in your system. It's a perfect way to fix what might be wrong without either having a federal regulator calling you or a consumer class action filed. Think of them as something positive that you can remedy or do something about. And I know I mentioned this earlier, so I don't want to disappoint. What could be the catch on the telemarketing? Well, let's just hop over to slide 29, actually 39. Here's where you might need to be concerned about the new written consent rules. Let's say you're an agency, you call a consumer, they're calling them on the residential phone, and you're calling to inquire about a debt. That consumer says, I'm really interested in a consumer credit report, I want to build my credit. And that agent then says, are you interested in purchasing a report, or make some kind of sales pitch? Well, guess what? What was ordinarily an exempt call for residential calls has now become a telemarketing call, because you've made a pitch, you've made some kind of upsell, and now you needed the prior express written consent under the new rules to have called that consumer. So ordinarily you don't need it for this type of call, but if you're going to make a sales pitch or make some kind of telemarketing part of that call, you need the new written consent. Very important. Keep that in mind. And I think we're pretty much out of time, but I will stay on the line for a few more minutes if people have questions. And I want to thank everyone for their time today.
Thanks, Christine. That is some great information. I think you gave away all your little secrets about obtaining consent, though. So.
Oh, I don't know. I still have more secrets.
Well, that's good. I think there's a lot of great information. Again, we got this recorded. We're going to have the slides out to everybody in the next day or so. So if you didn't get all of this written down, there's a lot of good examples there. And that's the same kind of questions we get. Well, what do you need to have in the consent? How likely is the consumer going to provide that consent? Especially the telemarketing consent has really got a lot of language to it. And so I know a lot of companies with telemarketing consent have had a hard time getting that from consumers, because the consumer looks at it from the point of, well, I got to consent to an auto dialer, I got to consent to a lot of things that maybe I'm not comfortable with. So let's go ahead and get through some of the questions that came up. Did you have any in particular, Christine, that you... Well,
I'm seeing a lot of questions here about how they get copies of the presentation. Ryan, I'm assuming you're going to make this available?
Yeah, what I'm going to do is send up a follow-up email within the next day with a link to get access to the slides and also access the recording. We'll put the recording on, we have a YouTube channel under Contact Center Compliance, but we'll get you the exact link so you can go in there and listen to the material as well.
And Ryan, can you skip to slide 40?
Sure.
Here is my contact information. I know there's a lot of questions here. This can be kind of difficult, and everyone has, a little different scenario. Please call me or email me if you have questions. I'm happy to help you as much as I can. I know I've given you a lot to chew on today, and you're probably going to have questions. So please send me an email or call me, and we can talk a bit about your specific scenario.
Let me go into the questions here. Sorry, I just have to open them up. Recording. One question we had was, does the disclosure need to be in close proximity to the place where the consumer provides the cell phone number?
Great question. Generally speaking, yes. You want to have the phone number, the disclosures, and the consent as closely approximated as you can. Because you want to be able to show, preferably when I defend these actions, I want to be able to give a document or a page that says, here you go, Your Honor, here was the disclosure, here's where they provided their phone number, and here's where they gave consent. All wrapped up into one document that I can present. That is very compelling when you go to court and you show that. I realize that not all of you are able to do that. You've got some lengthy loan documents, and you may not be able to tie it all together. There are ways to do that, tying the loan numbers and the documents, but the best way of doing it is make it all in one place, make it really clear, put it all together if you can. It is very effective.
What are some of the things that the professional litigators do when they go after a company under TCPA, and they're individual or in a class? Do they just go in and subpoena their phone records and find out how many cell phones have been calling and just assume that they're using a dialer? I mean, what are some of the things that you've seen that maybe can educate people that maybe have not seen that in their shop, or just have only read about some of these cases online?
Well, I defend a lot of these cases, and I've seen quite a lot in the TCPA space. I've been doing this for several years, and what I see, what has become the trend is you should pretty much assume that a professional plaintiff or a plaintiff counsel is going to assume that you've used an auto dialer. So what does that mean? That means that if you, let's say you're trying to do manual calls, you're going to need to carefully document what you're doing to show that it's manual. Because if you do get one of these suits, you want to get out of them right away, and you want to show, hey, listen, I didn't use an auto dialer, and here's why. If you are using an auto dialer, that's an issue that tends to be a very factual issue, and unfortunately, you probably can't get out of it very early in the case. To be honest, that issue is usually not resolved in these cases because the courts keep saying it's a factual issue. You say you didn't use an auto dialer, they said you did. You get discovery on it, and you have to kind of go the distance to get that question resolved. What really happens in these cases is they file them. It doesn't take a lot of work. They do a ton of discovery. They go through your data. They ask for all the phone numbers. They ask for all the information, and then what usually happens is a settlement, unless you're able to get the case dismissed. Your concern is the discovery. They're going to want to see everything. They're going to mine your data, and it's very hard to deprive a plaintiff from getting discovery to make their case. That is what is one of the most difficult parts about these cases. The discovery can wreak havoc in your business. It can be very time-consuming and very expensive. So, that's something that we have to keep in mind when we remain compliant so that we avoid these type of issues and this type of invasive discovery.
And I think the other thing is, there's no way to avoid calling cell phone numbers. It's going to be in your database, and they know that, 40, 50%, sometimes even more than that, depending on the type of demographic that you're calling, are going to be cell phone numbers. We do a lot of work with companies when they get into pre-litigation, or they're in these situations where they want to find out what the damages could be, and it's usually a pretty good percentage of records that end up being cell phone. We did a project for a client, big financial entity, and out of 25 million cell phones, there's 25 million unique numbers that were part of discovery. About 7 million of them were actual cell phone numbers, which isn't half, but 7 million times 500 or times 1,500, depending on how they assess the damages. My calculator on my iPhone, I don't even think goes that high. So
yeah, and it's a great point, Ryan, because what happens in these cases is, they realize they may not be able to get you for everything, but what they're going to look to do is to find your vulnerability. Where is your weakness? They're going to try to make a subclass of consumers that you've called. And, with the numbers at $500, or up to $1,500 per unlawful call, some numbers add up very, very quickly. They don't need to have everybody in their class. What they need is a really good subclass. And the easiest place to look is your mobile phones. You've got to be buttoned up on the mobile phones. Absolutely. And if you're not quite there yet, I encourage you to contact counsel, ask questions, make sure you've got that buttoned up, and you can avoid these types of lawsuits.
Like I mentioned earlier, anybody that wants to do a free kind of audit or evaluation of what they're calling, we can run data and determine which numbers are mobile based on being owned by the carriers, and also which numbers have been ported. Basically give you an idea of what percentage that you may have that is mobile. And let's say you have a solution in place to separate your calls for manual and for automated. It never hurts to check to make sure that you have a squeaky clean process, because it only takes a few situations, and we haven't even talked about the FCC, who can come after you for I think they're fined for a wireless violation, especially for TCPA for telemarketers. It's $16,000 per call or per violation. So I would expect to see in 2014, since they just changed the law, forget about the private litigants for a second, just the FCC in general. If they step it up, you can have other problems that could be even more dramatic.
Absolutely. So you not only have to worry about your class action plaintiffs that are looking to file their next big case, but you've got to be careful about the federal regulators. Even be careful about the state. You know, privacy is a big issue here in California, for example, and in many other states. You need to make sure you've got the compliance in place to avoid dealing with either one of these parties. Because once these actions hit, they could be costly to defend, and they could take some time before you get out of them. So compliance is encouraged, it's recommended, and it's really necessary in this particular climate.
And I think that's a good question to kind of end it on, and we've had one other type of question, which is, is there going to be another webinar coming up? I'm sure we'll do another one after the first of the year, kind of getting ready for 2014 or something of that nature. And you know, if you've got ideas or other topics that we didn't cover, we didn't get into the real intricacies of the differences between all the different types of dialers and manual versus automatic, but you know, certainly that's one area that I know you could spend a whole half hour, 45 minutes just talking about all the nuances of dialers, and whether it has a capacity, what is a manual call, are there state issues, and you got telemarketing mixed in there too, which can cause some issues. But I would suspect that we'll try to put something together first quarter to kind of kick off 2014, and we'll maybe even take, you know, there's definitely been a lot of cases out there that are worth looking at of companies that are up against TCPA litigation, specifically the business-to-business side. I've seen a lot of clients that are in stuff in the news where they're making B2B calls, dialing through an auto dialer. You get a lot of cell phone numbers mixed in there, business owners that use their cell phone, and just like that, then you've got a case that can, like Christine said, wreak havoc. So I think this is an excellent webinar, and hopefully everybody will have a happy holiday, and hopefully the professional litigators maybe take a break for the holidays, but I think that they'll be lining up soon enough, especially with the big impact with a lot of my customers has been the loss of the EBR, the ability to call your own customer on a dialer that you have a cell phone now. Now you got to put it in a manual campaign or something close to it. It's been a huge loss in productivity.
It is. Well, I'm sure we'll be doing some more webinars on this. In the meantime, if people have questions, please feel free to contact me. I want to thank you guys for listening to the presentation and participating, and I want to thank Contact Center Compliance for hosting this today. So thank you very much, Ryan.
Thanks again, Christine. Happy holidays, everyone.
Happy holidays.